So I'm going to go through and just tell you of several unrelated little tidbits that will help you in practicing at the Oakland County front of the court. One is the judgment information form and the verified statement. They're both loaded with confidential information. And every once in a while, I'll see on the listserv that those are supposed to be filed with the front of the court. And that's true, and those are stored in the front of the court file, which is confidential except to the parties and their attorneys. But in Oakland County, those are dropped off at the circuit court clerk's office. And you don't have to make a fuss about it with the clerk and say, I do not have to file this with you, I have to file this with the front of the court. You're not actually filing it there. We're just having you drop it off there, and it's really more for your convenience than anything. It will not be stored in the circuit court file. It will be stored in the front of the court file. They're completely accustomed to getting those and protecting the confidentiality of that information. So fear not when you're dropping it off over there. We'll get it and we'll take care of it. And along the lines of that confidential information, I want to talk about those domestic violence cases. We do have the ability in our computer system to mark an address confidential. So if there's domestic violence and one party is trying to keep their address confidential, we can handle that. But you do need to know that the court rule requires that an alternate mailing address be provided so that we're able to mail things to them. We're mandatory reporters now because of a law that was passed. And when we say we're mandatory reporters of child abuse, not of domestic violence. But we don't generally observe the child abuse in person. We do interview children, and sometimes they're in our office, but people are really generally on their best behavior when they're bringing their kids into our office. I mean, we do have the fights in the lobby and everything, don't get me wrong, but when they're bringing their kids to see us, they're not abusing their children generally. So most of what we get in terms of allegations of child abuse is because one of the parents is saying it about the other parent. And the state's training was pretty clear that you don't make the findings of fact about this. Child welfare does that. You report, and when in doubt, you report. So I tell you this to be cautious when you're making your pleadings, because there are friends of the court, we've talked about it in our association, who are taking this responsibility to kind of an extreme level, and if they see allegations of child abuse in a pleading, that may be reported. So put what you need to prove your motion in your pleadings, but also bear in mind that we have a responsibility now to report child abuse that we may not have even seen with our own eyes. We talked about the early intervention conference, and that's something that's specific to Oakland County. That's 56 days after the filing of a divorce. We hold those every morning at the front of the court except for Wednesday morning. And those parties and their attorneys are required to appear at that. There's a $250 fine per party if they don't appear. And that's not like, you won't get these most likely with your pro bono cases, but I did honestly have someone call me recently crying because they didn't know where their money was and they had questions about the system. And at the end of the conversation, she said, and I'd gone to college with this woman, she said, well, if I didn't know you, I wouldn't have been able to get this information. It's so wrong that the system is this way, that only people who have friends from college that work at the front of the court can find things out. And I said, didn't you go to the early intervention conference? And she said, oh, is that thing? We paid $500 so we didn't have to go to that. So it's not like we're charging you for not going. It's actually a fine for not attending because we want you to come. And we now have always done these since family division on divorces, but now we're doing them on privately filed paternity, family support, and custody cases as well. So if you're initiating under the Family Support Act or under the Paternity Act and not under the Divorce Act, we'll still schedule an early intervention conference with you. If you're representing someone who's having a family support case or a paternity case brought by the prosecutor, we don't require them. We'll do one if you call and ask. We tried to pilot on 5 dockets requiring them on those cases, and no one showed up. Because on the other cases, the privately filed cases, we can say, we're not going to grant your divorce if you don't show up, and we're going to fine you if you don't show up. But on these cases initiated by the prosecutor, we don't have that same kind of hammer if people don't show up. So We still do get involved in those cases, but we don't have the same mandatory early intervention. And at the early intervention conference, one thing we do is we provide the phone numbers for the team that's assigned to that case. And these are the direct line telephone numbers of everyone on the caseload for that particular case. We really promote the use of the direct telephone numbers of all the staff because our switchboard is very busy answering literally hundreds of thousands of calls a year, but there's only 3 people doing it. So we really want people to call their direct caseworker whenever they can. And we provide those phone numbers everywhere, on the website, in the office, and at the early intervention conference. For those of you who've been in the Oakland County front of the court, the North Hall has a bunch of cubicles in them, and they used to be used by staff people. But we had to lay off some people, and we were able to move them all into offices. So those are now available for you to use if you want to meet privately with a client. Regarding what we hear at the front of the court, it's a little different in all 3 counties, but at the Oakland County front of the court, we only hear those improper motions for custody, parenting time, and child support. And we have a local administrative order that you can see on our website about what exactly we hear. We also hear things that the court orders us to hear by entry of an order of reference, and you have to have an order of reference. For example, you can't get a referee hearing on change of domicile unless you have an order of reference. Often the judges will have the referees initial those at the motion call because the motion will be filed and it'll get referred to the front of the court. And sometimes the front of the court referee can resolve it right there on the spot at the motion hearing, and it's really not necessary to refer it. The fee waiver form is in your packet, but it's not on our website. It is a little bit different than the SCAO fee waiver form, and that's because it waives the fees. The SCAO fee waiver form just waives the fees, and it's unlimited forever. And we just think that circumstances change, and every time you want the fees waived on a case, we need to reconsider that. So our fee waiver form, which is in your packet, is good. Generally, the court can indicate it'll be good for whatever duration that the judge would like, but it's generally for this motion that you're filing right now, which will be like in the next 30 days generally. I will say on opt-out, yes, we have our own form order. That's in the packet. It's also on our website. The main difference between our form order and form motion and the SCAO version is that it requires mediation or arbitration before opt back in. The improper forms that are on our website, they're very helpful and useful, but those are for improper litigants only. So we do get lawyers, particularly pro bono lawyers, saying, wow, these are so handy, I'm just going to use those. But those really are for improper litigants, and they'll get sent back to you if you try to file them for a client. And the other thing is just about fees. Right now, you pay your judgment entry fee for custody and parenting time at the time of filing in Oakland County. But there was a law passed in January that requires the SCAO to set up that fee, although hefty, it may feel hefty, it's $100 to get a custody or parenting time motion filed. That does not come close to covering the cost of a front of the court custody or parenting time investigation. So SCAO is right now, as we speak, working on a fee schedule and to figure out how much a custody or parenting time investigation costs, and that'll be an additional fee if that issue gets referred to the front of the court for an investigation.